Welcome to Shenkman Education. My name is Marty Shenkman. This is another case study to illustrate how planning can go wrong. And what happened in this case study was daughter felt she was knowledgeable enough in estate planning that what she did for mom is she researched what mom should do for her estate plan. Here's what she came up with. She was going to take mom's house and put it into a qualified personal residence trust, known by the acronym QPRT or QPRIT. That was one of the three things that daughter had proposed. Made no sense. First of all, if you put a house in a QPRIT, you're trying to reduce estate tax. There may also be, depending how you structure it, asset protection benefits, but reducing your estate when the estate is so far below the estate tax as it was in this case made no sense. Why would you undertake a complex planning idea when there was no reason for estate tax reduction? Made no sense. Worse, you lose the tax basis step up on death. If mom owned the house when she died, the basis in the asset gets increased to its fair value. If the daughter sold the home after she inherited it, she'd have no capital gains. Now she's lost that benefit. You don't get the home sale exclusion if mom passes because now you just inherited the house. So it's a bad income tax result to save no estate tax. And worse, for mom's sake, what if mom in later years needs to sell the house or access through a reverse mortgage or a loan the value of the house so she can use it for her living expenses? You put the house in an irrevocable trust that mom can't access other than through her right to live in it. The whole thing makes no sense. Not to mention the cost and complexity it created. Another concept the daughter came up with is mom's going to set up an irrevocable trust, put a whole lot of her assets in it, and then daughter was going to contribute her assets to that trust as well. That becomes a mess. So who's the settlor, the grantor to the trust? From an income tax perspective, if two different people put money in a trust, they could both be taxed as grantors on the trust. You have to account for those interests separately. Very complicated from an accounting perspective. And why would you do that? Worse, if mom needs her assets, just like the example of the QPRIT, they're in an irrevocable trust. What access does mom have? Even more ridiculous is if mom is the settlor creating the trust, putting assets in it, daughter was going to name herself trustee. How do we know daughter's not just going to steal all of mom's money? And if mom is a beneficiary of the trust, which is what the daughter contemplated, but she'll be in charge of it, very worrisome to say the least. If mom is the beneficiary of a trust that she created, unless that trust is created in one of 20 states that permit that type of planning, the trust won't work. It's in her estate. Nothing's been accomplished. Her creditors can get at it. If she has an estate tax, which wasn't even applicable here, it accomplished nothing. That type of trust is a very sophisticated asset protection trust called a self-settled domestic asset protection trust, known by the acronym DAPT or DAT. So this other piece of the planning that daughter came up with was not only incredibly complicated, it didn't work at all, created income tax issues, no creditor protection. What mom probably should have done is had a more basic revocable trust planning as she was getting on in years to make sure she's protected. Mom probably, at the size of estate she had, should have at least consulted with a Medicaid elder law attorney to see if Medicaid planning was appropriate. Her estate may have been a little higher than what would have worked for that, but it should have been pursued just so she would know, and none of this other planning should be done. We didn't even get to the third idea that the daughter had because the first two were so awful. What's the moral of the story? Yes, it's great to do research online. It's great to understand what you're doing. It's valuable to use AI in trying to get some research to get background on something. But there's so many variations of estate planning that could be done. Why would you spend time just guessing at stuff? Why do you think that you would have the wherewithal, the knowledge to evaluate all the myriad of different estate planning options and pick what makes sense? It would make much more sense if you really don't know what should be done to consult with a specialist who does estate planning and can at least get you on the path to what makes sense or make recommendations that you may want to then do research and pursue. And a lot of estate planning, I see this kind of issue arise. People get in their head, it could be because an advisor has very limited background on estate planning, makes a recommendation, they read stuff online, and there's nothing wrong with reading stuff online, but you got to be careful. or they're playing, whether it's bocce ball or pickleball with somebody, and hey, I have a XYZ trust, you should too. Start with the basics, do the fundamentals, get some guidance on what you should do, and start from a practical perspective. If you want to just jump into guessing which of the acronym soup you want to use for your planning, you're probably never going to get anything that makes sense. And if you go as a client to estate planning professionals and say, I want an ABC trust, and I want a this, and I want a that, a lot of them, even if they try to explain to you what it is, they may just finally give in and say, okay, if that's what you're insisting on, I'll do it for you. It may not work, but I'm happy to do it for you. You need to get advice that works. You're much better off, just like when you go to a doctor, let them take the bloods, let them get, a physical exam to see what's going on. Let them hear your complaints of what hurts and what doesn't feel right, and make a diagnosis. When you want to do an estate plan, get a balance sheet of all your assets, get family data of all your family information, go to a professional and find out what you really should do. Get an estate planning diagnosis. That's what you should do. I hope this helps. Try to be practical. You'll get a much better result. Thank you for joining me. Please keep in mind that all the content on this video is for educational purposes only. Don't take any legal action without appropriate professional guidance. For more information, see shenkmaneducation.com. Thank you.